Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We will consider in this presentation a distinct legal element of the principle set out in Ralli Bros and its effect on the sanctions litigation. And more specifically, we will discuss the following points. We will set out the principle as such. Then we will consider two limbs relevant for the principle's application, namely the unlawfulness in the place of the contractual performance and the defendant being not at fault when claiming the reliance on the relevant principle, as well as its effect on the contract itself. The starting point is that if a contract between two parties is governed by English law, then the enforcement of such a contract in an English court will be decided without reference to any illegality which occurred outside of the UK, and any such act of illegality will be, as a general matter, irrelevant for the enforcement of the contractual obligations under the contract. By way of example, let's consider a situation when a Turkish borrower has to repay a debt to a French bank, and the laws in Turkey at the time of the payment require that a special authorization is obtained for the purpose of, for example, currency control restrictions available in Turkey, or prohibit this type of payments altogether. Or, for example, that a court order in Turkey is issued by the Turkish courts, which prohibit the payment to be made by the Turkish company to the foreign bank. Objectively speaking, at this situation, these type of events are outside of the control of our Turkish borrower, are the results of the acts of the state, and one might logically consider that they should suspend or discharge the borrower from compliance with its payment obligation in a way envisaged in the contract, at least for that period of time when such events continue. But nevertheless, the general position is exactly the opposite. In an English law contract, as a general matter, foreign law illegality, so the illegality which occurs outside of England and Wales, is irrelevant and will be disregarded for the purpose of enforcing the contract. So without more, in the example which I've given, the debt by a Turkish company to a French bank under an English law credit agreement will be due and payable in accordance with its contractual terms, regardless of those types of events, objectively speaking, affecting the possibility of a Turkish borrower to discharge its payment obligations. Ralli Bros and the following line of cases is a recognized exception to this very harsh rule. The exception operates in a way that, to the extent the performance of the contract is unlawful in the place where performance is due, then English courts will not enforce such a contract on condition that the relevant defender is not at fault in connection with the events preventing the performance occurring. The principle is the main principle which is relied in connection with foreign, that is to say, non-English illegality events preventing performance is currently almost always used in the circumstances when sanctions prevent performance by a debtor of the obligations under a contract, and accordingly, this would be the focus of this presentation. It's important to mention that Ralli Bros is the most common, but not the only situation when English courts in principle can grant the recognition to the illegality in foreign jurisdictions. In principle, the courts were willing to keep the door open for other circumstances outside of the Ralli Bros principle, which may result in the same result, namely that the contractual breach will be excused. And more specifically, Justice Bright, speaking obiter in the recent case where Eurahim, being a Russian company, wanted to enforce on-demand bonds issued by a French and Italian bank, Justice Bright mentioned that the principles of comity, which are the basis for Ralli Bros itself, may justify the extension of those jurisdictions which laws will be taken by the English court into account, and he set out non-exhaustive criteria which will be relevant in this type of analysis, mentioning that should he need to engage in this type of analysis for the purpose of deciding the case, which he did not need to, he would excuse the breach of contractual obligations on this wider principle of comity. More importantly, for the purpose of our presentation, Justice Bright in principle recognized that EU sanctions laws, to the extent they're similar to the English laws, and they are substantially similar, as of today, would benefit from this principle. It is to be seen whether this, as a general matter, will be accepted by other English courts. Nevertheless, that's an important point to consider within the scope of this presentation. Having said this, we would focus today specifically on Ralli Bros, being the established and most often pleaded principle in the circumstances when sanctions result in the illegality which prevents performance of the contract. As discussed, to successfully plead Ralli Bros exception, 2 points have to be established by the defendant, namely that the act of performance of the contract is unlawful in the place of performance. That's one of the key elements of this principle, which is subject to most of the litigation. And the second element is that the defendant is not in fault. So we will start by considering the first limb, namely the place of performance, where the main distinction is between the act which is required in the place of performance, in the jurisdiction where the contract needs to be performed, and so-called preparatory acts, or acts leading to the equipment of performance, which may be required in many other jurisdictions. The dilemma here is quite obvious. The party relying on the principle would wish to expand its application to as many jurisdictions as possible. So, for example, in my earlier example of a Turkish borrower having to comply with its payment obligations, let's say in euros, to a French bank, would wish to expand the application of the principle to as many jurisdictions as possible, for sure to its own jurisdiction of incorporation, as the laws of that jurisdiction will be most relevant for the borrower's ability to perform its obligations, like in the example given, the currency control laws or any kind of court prohibitions in Turkey for the discharge of the obligations. But similar, if our Turkish borrower has accounts, for example, with an Austrian bank in euros, which in turn will process the payment to the French bank through its correspondent bank in Germany, then certainly these jurisdictions equally become relevant for the practical ability of our borrower to discharge its payment obligations. So from the borrower's perspective, as many jurisdictions as possible shall be joined to the case, and at least the jurisdiction of its incorporation, Turkey, the jurisdiction where its bank and correspondent banks are located, in our hypothetical Austria, Germany. Conversely, at the creditor's end, the logic will be exactly an opposite, to reduce the number of jurisdictions to the minimum possible, ideally to the jurisdiction of the creditor's own location. Under English law, the principle operates as a very narrow gateway, and the courts will strictly define the relevant jurisdictions where performance is required, and will exclude any other jurisdiction on the basis that the acts necessary in those jurisdictions, even if affected by illegality, is nothing more than preparatory steps to the performance, or as the courts call them, are equipping the borrower to perform. In a case of payment obligation, the relevant jurisdiction will typically always be only the place where the creditor's account, where the payment has to be made, is located, which typically, but not always, will be the jurisdiction of the creditor itself, on the basis that, as a general point of law, the debtor shall seek his creditor to discharge the payment obligations. So in my example of a Turkish company, without more, the default scenario will be that as the payment obligation has to be discharged in France, to the accounts of the French bank located in that jurisdiction, only the laws in effect in France will be taken by the courts into account for the purpose of application of Ralli Bros principle, and only to the extent the laws in France make it illegal for the borrower to pay to the French bank the relevant amount of money, will the borrower be excused from the relevant payment obligation. As we can see, the principle is very narrow, very strict, and difficult to satisfy in practice, as it's highly unlikely that in practical terms, any type of sanctions will operate in a way that they would affect the local creditor to receive a payment from a foreign debtor, which is subject to the sanctions, without leaving any kind of gateway or a possibility for the relevant parties to obtain a license from the relevant sanctioning authorities to discharge the performance. As it's quite clear that typically the sanctions would aim to penalize foreign companies, in my example, foreign debtors, rather than locally incorporated companies. So it's a very narrow gateway, which would be difficult to plead in connection with a regular payment obligation. Having said this, the place and the jurisdictions which illegality may affect the contractual performance may be expanded, primarily into circumstances. The first circumstance is when the contract explicitly sets out that certain jurisdictions need to be engaged in performance. Then, in addition to the jurisdiction where the default criteria of performance will cover, all those jurisdictions which are covered by contract will also be included for the purpose of Ralli Bros analysis. So, for example, in my example, certainly to the extent the contract explicitly mentions that illegality in any of Turkey, Austria, Germany, or France will excuse the performance, then the performance will be excused in case of any events in any of those jurisdictions affect the ability of our debtor to discharge his contractual claims. But even in the absence of such a clear provision, which is highly unlikely to be found in a credit agreement, other type of provisions which originally the parties may not think to operate in a way as expanding the number of jurisdictions where illegality events may affect the performance may be interpreted in a similar way. One more common example are the payment instruction provisions, which may mention specific banks which will need to be engaged in the routing of the payment. If a credit agreement has these type of provisions, then it's likely that the courts will interpret these as imposing a specific method by way of contract, how performance has to be conducted. And as a result, each of those jurisdictions, to the extent affected by illegality, will need to be considered for the purpose of Ralli Bros analysis. In addition to contract, the nature of obligation itself may expand the number of jurisdictions where illegality events may excuse the party from what would otherwise constitute a breach of a contract. Two examples can be mentioned here. One of them was considered by the courts in the case of Benithko Company, that was a client of an English broker, and it made a claim against this English broker to transfer to it some clients' money, which were held by the broker. So on its face, we have a standard payment obligation, which we've just discussed at length, and then applying the analysis, which we've just mentioned, only the place where such obligation has to be discharged. In this case, again, applying the standard default position, the place of location of the creditor, being Benithko, a company located in the United Arab Emirates, need to be considered. Under the laws of the United Arab Emirates, there was certainly no illegality event occurring, and so applying the analysis we've just mentioned, we may come to a conclusion that the English broker was obliged to make the payment obligation. Nevertheless, the conclusion in the case was the opposite one, that the broker was excused on the basis of Ralli Bros principle. And the reason for that is that the court considered that the payment obligations of the broker is not a common obligation to repay debt, where only the jurisdiction of the creditor would be relevant, but is an obligation to transfer specific trust monies held by the broker on behalf of its client. And as that obligation of transfer related to that specific sum of money held by an English broker, then the chain of the banks which are necessary to be engaged for the purpose of that transfer would have to be added as the jurisdictions where illegality events may excuse the contractual performance by the broker of its payment obligations. In the case of the case, those events occurred in the United States of America, and the courts found that to transfer US dollars specifically had by the broker on behalf of its clients in the UK to the United Arab Emirates, the US jurisdiction will need to be engaged, and accordingly, the illegality in that jurisdiction will need to be added to the illegality analysis in the jurisdiction of the location of the creditor. On the same basis, the nature of obligation requiring acts to be done in more than one jurisdiction for the purpose of its performance. Mr. Justice Bright, again in the European case, which we've discussed earlier, expanded the scope of the jurisdictions in case of documentary instruments of payment. In the case, these were on-demand guarantees, by saying that in addition to the jurisdiction of the location of the creditor, as would be the case for a common type of payment, the jurisdiction of the location of the payer will need to be added for documentary type of transactions, because in those type of transactions, the processing of documents against which the payment is made is as important as the payment itself. and the processing of documents occurs in the jurisdiction of the location of the debtor and not of the creditor. And on this logic, the court held that for these type of obligations, both the jurisdiction of the creditor and the jurisdiction of the debtor can benefit from Ralli Bros exception. Second element, which is necessary to rely on the exemption, is that the act shall be unlawful. There is less contention as to what unlawfulness means, especially in the context of the sanctions litigation. Nevertheless, it's important to mention here that unlawfulness so far has not been interpreted by the courts as meaning only criminal type of unlawfulness, so the act which may result in criminal sanctions, but civil unlawfulness or administrative type of sanctions will also suffice. In the case of sanctions litigations, this question is largely moot because the breach of sanctions will be a criminal offense in almost any jurisdiction. Nevertheless, it's an important point to take into account. Second point, which is, let's say, more counterintuitive, is that for the purpose of determining whether an act of unlawful, the courts will look at the events which result in unlawfulness under a law or a regulation in a foreign jurisdiction, but will not consider for the purpose of unlawfulness the decision of a foreign court which prohibits some type of behavior. So going back to my original example of a Turkish borrower having to repay a loan to a French bank and being prevented from doing so by two types of restrictions. First, foreign currency control restrictions imposed by Turkish authorities, which prevent the payment to offshore jurisdiction. And second, a Turkish court order, which stems, for example, let's assume, explicitly prevent this type of payment to a specific bank. Only the first category of restriction can be relied on for the purpose of Ralli Bros principle, namely restriction arising under law. So in my example, coming from the currency control restrictions. Conversely, although this may sound counterintuitive, the decision of a Turkish court, which to a certain extent is more explicit in terms of its prohibition to make a payment to our Turkish borrower, and certainly the breach of that order in many jurisdictions will result in criminal penalties, both for the bank, both for the borrower and for most likely its employees as a type of contempt of court, will not allow the borrower to rely on Ralli Bros principle. The explanation for what may sound not a accurate conclusion is that under English law, Ralli Bros principle is viewed as a conflict of laws rule, which in certain circumstances requires the application of foreign laws, and accordingly, they will not apply to the foreign courts, which recognition follows a special procedure. To the extent the defendant successfully pleaded the unlawfulness in the place of performance, the defendant may still not be able to rely on Ralli Bros principle if the courts find that defendant could have done something to avoid such unlawfulness, but failed to do so. Most commonly in the context of this requirement, we talk about some types of licenses, which could have been obtained in the jurisdictions where the prohibitions are introduced. This is specifically relevant in the context of sanctions litigations, where most of the restrictions, however harshly framed, would be subject to an opportunity to obtain a license or an authorization, but not only. For example, the failure to make the performance on time and the subsequent introduction of the illegality-related restrictions is likely equally to be considered as a fault of the defendant, and accordingly will not allow the defendant to rely on Ralli Bros principle to excuse its performance. Nevertheless, in the context of sanctions litigations, the most important point to consider is the application for a license, because failure of a party which potentially wants to rely on Ralli Bros principle to apply for a license will make such party at fault, and regardless of whether that party may or may not be granted a license, the failure to do so may substantially prejudice the reliance on the principle. So it's important that such an application is made as promptly as possible, that the party satisfies the court that it did its utmost, or to be more precise, took reasonable efforts, to quote from the case, to obtain the license. For doing so, the application at minimum has to be made promptly. The application has to be drafted in a neutral way, not in a way which conditions somehow the authorities to be more likely to refuse the application rather than to grant it, and certainly has to avoid inaccuracies or omissions which can later be criticized in the course of the court proceedings as a reason why the application was either refused or delayed. So it's an important element because many cases turn on this basis. The courts recognize that potentially Ralli Bros principle may be engaged, but then they are not satisfied that the relevant party took reasonable efforts to actually overcome the illegality effects, which in the context of sanctions primarily means making diligent license applications. If Ralli Bros principle isn't engaged, then the effect of it is that it suspends the performance of a payment obligation under a contract as far as the illegality event continues in the place where performance is necessary. So just a suspension, it's not a termination of the relevant obligation, which is important to consider. And for other obligations, the obligation will be considered to be invalid and unenforceable. Thank you very much for watching. I trust that you found this presentation useful, and I hope to see you during my next presentations.